Fordham University law professor Cheryl Bader is joining us now to talk more about the former president's legal troubles.
She is a former federal prosecutor and joins us now by Zoom. Good morning, Cheryl.
Good morning. It's good to be here.
So we just heard Elijah talk a bit about how this proceeding will be different. We just want to dig in a little bit more into this state court arraignment versus federal court.
Right. So this is what's called a voluntary surrender, and he's going to be surrendering to officials. And they're saying that they're not going to give him the kid glove treatment that he's gotten in the past, that we might see the first mugshot. They're still, I think, negotiating over whether there'll be certain other indignities that most criminal defendants have to go through, like being searched, being weighed, and things of that nature. But he won't be held over for an initial appearance because they've already agreed to the bond that will be set for him and the conditions. And interestingly, here, all the other co-defendants, one of the conditions is that they not intimidate other witnesses, that they not speak to co-defendants except through their counsel. But here with Trump, they've added some additional language that actually explains very explicitly that he's not to post or repost any social media that might, in fact, intimidate any witnesses or harm the community.
Now, Cheryl, you mentioned the bond that has already been set at $200K. Is that pretty standard?
So normally I think it is for a case like this, of this magnitude, for that amount. But remember here that bail is set so that somebody comes back to court. Right. And Trump is really not likely to flee the jurisdiction. I mean, where would he go that he wouldn't be recognized? So in all the other cases, bond wasn't set, and I don't think it was necessary here, but it is standard that amount would be set.
Now, as we've been hearing and talking about, there will be a camera in court. Do you see that as a distraction?
So I think it's certainly something that Trump doesn't want to have. And if he tries to remove the case to federal court, they wouldn't have cameras, but in Georgia, they will. And I think this is something that Trump does not want to have the cameras trained on him when he's sitting in the defendant's chair. Right here it is, the prosecutor is going to be able to speak to jurors. The prosecutor is going to be able to actually show facts to the jury. The judge is sitting up on the bench above Trump, running the show. Trump prefers to have the cameras trained on him when he's in control of the situation and he can spin things in his way. So I don't think he's going to be happy about the cameras in the case.
Now, there are reports that Mr. Trump is trying to move the case to federal court, possibly to get more sympathetic jury pool. Do you think that's likely?
So I understand that he and some of the other defendants in the case are going to be filing those motions, and it would still remain that the prosecutor is the prosecutor on the case. It would still remain that he wouldn't be able to pardon himself because it's a state prosecution. But on the other hand, he would get a broader jury pool, not just Fulton County, and that could be helpful to him. If I'm the judge, I'm not going to grant that motion because it's based on the defense has to show that he was acting under color of federal law. In other words, his position. So if I'm the prosecutor, I'm going to argue that it's not his job as president, right, to interfere and overturn the election. And that's not acting under color of his federal duties.
So you've walked us through what happens up to the court appearance. How about after?
Right. So in this case, it's a very complex case. There's a RICO count, which is a very broad count that brings in a lot of different criminal activity. You have 19 defendants, so that's 19 defense attorneys. 19 people making multiple motions, having to prepare for the case. So I think it's unlikely that this case is going to be able to go to trial before the election happens. I know that the prosecutor will be asking for that. And of course, Trump and his team, they often, delay is their typical tactic. And I think in this case, Trump feels that's probably his best defense. If he can delay the case until after the election, then you can't try a president while he's sitting, so that would potentially buy him 4 more years before the case could even come to trial.
So Mr. Trump is now facing 4 separate indictments. How will this be scheduled or prioritized?
So that's a very difficult question, right? DA Bragg has said that he's willing to step aside and put his case behind, at least the federal cases. I think the case that has the best chance of going forward is the federal case based on the overturning of the election, because in that case, special counsel has really made an effort to streamline the case. In fact, it's very similar to the case we see in Georgia, but there Donald Trump is the only defendant in that case, and we just have 4 charges that were levied against him. So I think that's a real effort to streamline the case and get that tried potentially before the election.
Fordham Law School professor Cheryl Bader, thanks so much as always for your insights.
Lots to bring to him, yes.
And stay with CBS 2 all day for continuing live coverage on the Georgia elections case as Trump is set to surrender. And to read the criminal indictment, head to cbsnewyork.com.